Hello and welcome to the Week in Pensions, brought to you by the pensions team at Gowling WLG. I'm Chapman-Curry, and each week I bring you the latest developments on pensions law and regulation, along with general news highlights from the world of pensions. You can find out more about the pensions team at Gowling WLG and sign up for our alerts by visiting gowlingwlg.com/pensions-UK. Our first update is that the Court of Appeal has ruled on the long-running equalisation case of Safeway and Newton. This judgment focuses on the interaction between the introduction of the equal treatment rule into pension schemes under Section 62 of the Pensions Act 1995, the equal treatment requirements of what is now Article 157 of the Treaty on Functioning of the European Union, but which at the time of the purported amendment was Article 119 of the Treaty of Rome, and a deed of amendment that sought to level down benefits with retrospective effect. The Court of Appeal has found that normal pension age equalised at age 65 in the Safeway pension scheme on the 1st of January 1996. This was the date that Section 62 of the Pensions Act 1995 came into force and inserted the equal treatment rule into scheme rules. The equal treatment rule conferred enforceable rights on scheme members to have equalised levelled up benefits. The Court of Appeal determined that this was an effective measure in line with the requirements set out in the ECJ's judgment that equalised normal pension ages at age 60. As a result, the Barber window for the Safeway pension scheme was closed on that date, i.e. the 1st of January 1996, and the Safeway scheme's equalisation deed, dated the 2nd of May 1996, could have its intended retrospective effect to level down to a normal pension age of 65 for men and women in the Safeway pension scheme on and from the 1st of January 1996. An important point was that the court agreed with Safeway Limited's submission that the coming into force of Section 62 was sufficient to close the window. The court commented that even if EU law requires the scheme itself to be modified, Section 62 has this effect. It cannot make a difference that the modifications are initiated by Parliament rather than the administrators of the scheme. Importantly, from the effective date of Section 62 of the Pensions Act 1995, i.e. 1st of January 1996, the EU treaty rights ceased to apply to the equalisation of NPAs. Therefore, the equalisation deed could retrospectively level down benefits, but only on and from the 1st of January 1996. For the period of accrual from the 1st of December 1991 to the 30th of December 1995, EU treaty rights prevented the deed from having its intended retrospective effect. On the 8th of July 2020, the Chancellor of the Exchequer, Rishi Sunak, delivered his summer 2020 economic update. Of interest to pensions practitioners will be the announcement of a new Kickstart job creation scheme aimed at those aged between 16 and 24 who are on universal credit and at risk of long-term unemployment. For each new placement, the government will fund 25 hours work a week at the applicable national minimum wage, plus the associated employer national insurance contributions and employer minimum automatic enrolment contributions. The Chancellor also confirmed that the furlough scheme will finish at the end of October 2020. The Pensions Ombudsman has predicted a surge in pension scam and ill health claims due to financial impacts of the pandemic. Anthony Arter, made his comments at a House of Commons Work and Pensions Committee hearing last week, in which he anticipated that the number of complaints concerning pension scams and ill health pension schemes claims will undoubtedly increase due to the impact of the COVID-19 pandemic. In addition, Anthony Arter highlighted another risk for pension savings, that as employers continue to cope with the financial impact of the pandemic, some may fail to pay contributions into pension schemes or could encourage members to opt out of their auto-enrolment schemes. The Pension Protection Fund, moratorium and arrangements for reconstructions for companies in financial difficulty regulations 2020 have gone into force. The regulations are made pursuant to the Corporate Insolvency and Governance Act 2020 and provide specific protections for pension schemes during a moratorium and when a restructuring plan is proposed. Broadly, the regulations enable the PPF to participate in key decisions in the process by enabling it to exercise creditor rights that would otherwise be exercisable by scheme trustees. Where trustees lose their rights because of this, the PPF is required to consult with those trustees. The regulations came into force on the 7th of July 2020. And more news from the Pension Protection Fund, the PPF has released guidance on the subject of how to submit information regarding moratoriums and restructuring plans. This follows new restructuring and insolvency requirements that came into force on the 25th of June 2020 as part of the Corporate Insolvency and Governance Act 2020. This requires restructuring professionals and insolvency practitioners to notify the PPF and share documentation with it in relation to a moratorium or restructuring plan if an eligible pension scheme is involved. This information must also be provided to the pensions regulator. Also this week, the Department for Work and Pensions has explained its belief that although there are great risks arising from climate change, the challenges nevertheless present the greatest commercial opportunity of our time. In an article for The Telegraph, the Pensions Minister, Guy Opperman, stresses that the key role pension schemes can play in seizing these sustainable opportunities, for example, through financing green technology. The article also welcomes the recently launched Make My Money Work campaign, which aims to encourage pension savers and encourage sustainable investment. So overall, another indicator of the DWP's direction of travel as regards climate change risk and green investment, and the role that pension schemes can play in developing a greener economy, as also evidenced by the recent government amendments to the Pension Schemes Bill. And to finish off the week in pensions, a couple of highlights from the Pensions and National Press. Pensions and Investment reports on Mercer's latest pensions risk survey data, which shows that the accounting deficit of defined benefit pension schemes for the UK's 350 largest listed companies increased from 72 billion at the end of May 2020 to 90 billion on 30th of June 2020. Liability values rose by 24 billion to 957 billion at the end of June, compared with 933 billion at the end of May, and asset values were 867 billion, an increase of 6 billion compared to the corresponding figure of 861 billion at the end of May. The Financial Times has focused on the prospect of interest rates being lowered to negative rates, stating that this could be a doom loop for pension investors. In the world of pensions, negative rates pose challenges for insurance companies and pension plans that are obliged to use bonds to honour income guarantees to the end savers. They can also result in people having to save even more to compensate for the prospect of reduced retirement income, with the resulting impact on the economy of lower spending. And that's all from the Week in Pensions for this week. Just a reminder that you can find out more about the pensions team at Gowling WLG and sign up for alerts at gowlingwlg.com/pensions-UK. Also, if you'd like to get in touch with me, all my contact details are available at tinyurl.com/GWLGICC. Until next time, I hope that you have a great week in pensions.